So a few years ago, when I still worked at Just Us, I helped a lady get housed in social housing, and basically it all kind of worked out nicely. However, she had been victim of domestic abuse, and her ex-partner basically made her life a misery, basically sabotaged the tenancy, would essentially try and gain entry to the block of flats. When she didn't allow him in, he would smash windows up, cause lots of criminal damage, cause loads of issues with the neighbours, and effectively that led the landlord to taking action to evict her. Now, I was able to delay that somewhat, because effectively when you look through the notes, the only thing confirmed that she'd actually done in any of this was she left a bike in the corridor. And yet essentially the landlord's position was, because she was allowing the ex-partner into the block, who then caused these issues, she was therefore responsible for it. And as far as I know, they never raised any safeguarding alerts to the council through that process. And her protestations that, you know, if she didn't let him in, he would smash the windows up, and the evidence for that was not really heard. So I left Just Us a couple of years ago, and since then basically she's become homeless and has reapproached Bedford Borough Council, who said that she was in priority need but intentionally homeless. Let's say her name's Emma, just to kind of make it easier to follow. And effectively Just Us got back in contact with me and just said, look, can you remember anything about the situation around her eviction that might just help us out challenge this decision? And I said, yeah, nice and easy. I made, I think, a couple of safeguarding alerts to the council at the time based on the information I had. Just look at that information, then the argument that she's not intentionally homeless should be pretty straightforward to make. So sure enough, that's what happened. They asked for a review under section 202, and the decision was very quickly overturned, because the council itself was sitting on a whole bunch of information which should have been taken into account in that section 184 negative decision that wasn't, and that led to the situation here. So I thought, given those kind of situations that arise often, it was worth just looking at safeguarding and homelessness in a little bit more detail, because in effect safeguarding issues can come up in all 5 of the 5-part tests. So homelessness, eligibility, priority need, intentional homelessness and local connection, they can be relevant in all of those different situations. And yet when I train professionals from around the country, often what I hear back is that professionals have effectively given up making safeguarding alerts because it doesn't seem like anything happens with them. It's a bit like duty to refers in that sense, where hospital staff just give up making referrals because they don't seem to work. But with safeguarding, there's a couple of actual good reasons why they don't have the outcome that a lot of professionals think they should have. So I'm going to talk about that and kind of go into a bit more detail. And I'm going to start just by looking at the kind of training that professionals should have in the sector, because if you work for a professional organisation, you should have had basic safeguarding awareness training. If you haven't, go check out your HR right now and get on that training. And a lot of these courses, and certainly historically, they were actually free to access, as in the council would deliver the training, because the training itself will be based on the local adult safeguarding policy. And effectively, I'll give an example of Bedford's in a second, but I guess it's important to understand that there's 2 thresholds in operation in the safeguarding process. There's a threshold which dictates when you should make a referral, and then there's a threshold which basically says whether or not the council should proceed with the safeguarding inquiry process past that stage 1 assessment. So if we actually look at a couple of excerpts from the local safeguarding policy in Bedfordshire, and again you just need to check out your own local policy because it will say similar things. So here we see aims of the policy. Immediate response. Secondly, identifying when serious issues or concerns that abuse, maltreatment or neglect are occurring and take prompt action to stop it. Thirdly, ensuring that abuse is taken seriously and acted upon on the basis of a zero tolerance approach. And fourthly, ensuring that wherever abuse, maltreatment or neglect are suspected or reported, that there is an effective, consistent and coordinated response through the comprehensive application of multi-agency procedures. And if we actually look a bit further down in that policy, it kind of states what people should do, what professionals should do when they become aware of abuse. And here in this section here, what to do if someone is hurt or discloses abuse. Anyone who first becomes aware of concerns of abuse must report those concerns as soon as possible. And I have not inserted the bold, underlined, capitalised letters that's in the original policy. The point being that this is supposed to be a very, very assertive response to concerns of abuse. And the way that staff are trained, you know, any professional staff, not just council staff, is that if someone tells you they might be being abused, or if information comes to light that they might be being abused, you should legally seek consent to refer their case to the adult safeguarding team. There are some intricacies around that which I won't go into here. And in effect, the adult safeguarding team in the local council will then investigate to some level. And as I say, this is a very, very low threshold. It's a little bit like the homeless application process. If someone might be being abused, you shall refer them as soon as possible. Basically, that's the way it should work. Interestingly, one of the things I used to push for in Bedford was the idea that professionals dealt with homelessness in the same way that the policy said abuse should be dealt with. So as in, we take a zero tolerance approach to homelessness. If someone tells us they might be homeless, we basically make an immediate referral, but that's an aside. So that's the initial threshold. The safeguarding team then apply Section 42 of the Care Act. And so Section 42 of the Care Act is all about safeguarding. It basically sets out how it should all work. And there are 3 criteria in that section which all have to apply for the safeguarding team to then take further action. There are a couple of intricacies which I will go into here because it's useful anyway, I think. In many cases, the first 2 criteria will be satisfied when we make referrals. However, the third one often won't be, and I'll explain why it is in a second. So here's Section 42, which basically says this section applies where a local authority has reasonable cause to suspect that an adult in its area, whether or not orderly resident there, A, has needs for care and support, whether or not the authority is meeting those needs. So let's just break that down for a second, because care and support needs is a very kind of generic universal term. It's not actually very well defined within the Care Act, but what the Care Act does allow is councils to set criteria on care and support needs, which basically states when they will step in. And so I think most councils, if not all councils, have like a list of kind of different support needs. And if someone needs support or care in more than 2 of these areas, if they tick 2 of these boxes or more, then they'll get some kind of service or some kind of package of support from the council. But even if someone doesn't meet those 2 criteria, or those minimum 2 criteria, that does not mean to say the council can't signpost them to other services or commission other services to deliver care and support. So that's kind of the way that would work. So you're going to have people who genuinely have care and support needs, but they don't have eligible care and support needs, and therefore they won't be getting some kind of support package from the local authority. So in one sense, I would say that if someone's accessing some sort of professional support service, that would be very, very good evidence that they have some kind of care and support needs, even if it doesn't kind of meet that 2-stage criteria. So that's the first one. Secondly, they're experiencing or at risk of experiencing abuse or neglect, and that includes self-neglect. I'll give an example of that in a little bit. And then thirdly, this is the one which kind of gets much more interesting. As a result of those care and support needs, is unable to protect himself or herself against the abuse or neglect or the risk of it. Now, this is the one where a lot of safeguarding referrals fall down. It's not that they fall down, it's just that they don't meet this criteria. Let me give an example of a situation where this would kick in. So let's say you've got someone with fluctuating mental capacity. So they've got care and support needs. And let's say when their capacity is kind of not, kind of in question, they might have some sort of wrong uns who are basically targeting them or maybe taking money off them, something like that. And effectively they might be giving money over to them even. And so in that situation, they have care and support needs, they are being financially abused, and it is because their lack of capacity in this example that they are basically not able to protect themselves and take evasive action for, again, for want of a better term. And so as I say, that would be an example of where it would kick in, but in most cases that you actually refer or people reporting they're being abused, they don't have that dynamic operating in their case. So yes, they might have care and support issues, and yes, they might be being abused, but their care and support needs is not the thing that's preventing them from taking evasive action. As I say, there's going to be lots of situations where actually people with capacity will, in some sense, be choosing to remain in difficult situations. I appreciate that's a very clumsy way of putting it, and I'm not going to explore that more in this video. But you're going to have a lot of cases like that. And so when you make a safeguarding referral to the council and it comes back to say we aren't taking this to stage 2, that does not mean to say the council says there isn't abuse and the person doesn't have care and support needs. It's most likely saying that that third criteria isn't actually been met. So that's the first reason why these safeguarding referrals often don't seem to be very effective. And the second reason is actually, even when all 3 criteria are met, the social worker's job is not to magically fix everything. The safeguarding social worker's job is to work with the individual, with their supporting professionals, to essentially empower them to take evasive action themselves. And there will be cases, as I say, where they've got fluctuating capacity and they can't do it, and that's when other things will be put in place. But in a lot of these situations, the social worker's job is just to explore the different meanings that that situation has for them, and why effectively they might be remaining in an abusive situation, and essentially what the pros and cons are. There is this term of unwise decisions within social work, which I don't like at all, because I would say, in line with what Alfred Adler used to say, is that there's this idea of private logic. And so when someone is doing something which might not seem obviously clear why they're doing it, there will be a reason, it's just that we haven't yet understood it. So I'd say, I think social workers and any professional should take time to understand why someone may be taking action which, on the surface doesn't seem to be very sensible. Anyway, that's an aside. So As I say, social workers' job is not to magically fix everything. It is to try and empower the individual to kind of take action themselves. And yes, there will be times when the police will be involved and the police kind of do their stuff over there. But the social worker's job is not, that's not their primary kind of reason for being involved. So those are two good reasons why safeguarding alerts might not seem to result in any sort of assertive action. However, within homeless applications, there is still a huge amount to be gained by following these policies. And the first thing I'd say is that if you're trying to challenge a council's practices, if you're trying to drive up standards, it's really important that you follow policies, that you follow the law, effectively, so you can't be accused of being a hypocrite, if nothing else, because it undermines your situation if you're telling the council they haven't followed the process when actually you don't follow the process anyway. So that's, again, a bit of an aside. But I'll give you some examples of when this can be relevant. I've got a few examples from my own casework and some probably more sort of nebulous ones as well. So in terms of the idea of whether someone's homeless, I'll give an example where it's actually one of the cases I discuss in the training I deliver. So that's a little bit of a hint there. If you haven't done the training, get on it. In the case study, the individual's known as Ruth. It's not a real name. And effectively, she had some undiagnosed medical issues which were affecting her mobility. She'd actually fallen down the stairs several times, taken other sort of trips and falls in the house. And on one occasion, she fell down the stairs and basically knocked herself out and broke some ribs. She phoned an ambulance, I think whilst lying on the floor. The ambulance attended, looked at her situation, looked at kind of her living conditions and basically raised a safeguarding alert for self-neglect. That referral then went to the adult safeguarding team, who came in and actually did a fantastic piece of work with her. So they kind of realised she had eligible care and support needs. They put a package of support in place for her anyway. But crucially, the assessment process that took place from social work was enough to then take to housing and say, look, yes, Ruth has a tenancy, but it's actually the case that she is homeless through the fact it's unreasonable to continue to occupy it because of the unsuitability of her, regarding her medical needs. And actually, had we not had that assessment process take place through the safeguarding alert, it would have actually been much more difficult because the medical conditions weren't yet diagnosed. So there wasn't anything kind of hard and fast in there had it not been for this evidence from the social worker. So that's an example of how it can impact homelessness. It can even affect eligibility because within the umbrella of no recourse to public funds, you have people who are on a spousal visa and they're subject to domestic abuse, which again should prompt some kind of safeguarding referral. Then that can then lead to the destitute domestic violence concession, which is basically a short period of time where people can get an additional support to try and find some other alternative options for them going forward. And then with priority needs, obviously it's going to come into force in a lot of different situations involving vulnerability, because vulnerability itself specifically mentions the risk of being exploited and abused within the law. And going back to one of the first cases I worked on in Bedford, there's a lady who basically had type 1 or type 2 diabetes, but she also had a learning difficulty and had been subject to domestic abuse from her ex-partner's family, if I remember correctly. Now, the counsellor said she wasn't in priority need, and that's when we got involved. So we challenged that, basically didn't get anywhere. But in assessing her case, basically she told me she'd kind of been subject to this abuse from her extended family or partner's extended family. Raised a safeguarding alert. Again, that resulted in a social worker getting involved, did a really kind of good assessment around her learning difficulty and how that might kind of impact her ability to kind of take safeguarding measures herself. And I then fed that assessment back to housing, to the colleagues in housing, to say, actually, we're going to do a fresh application here. There's new information. And that was actually enough to show that she was in priority need and therefore, she was housed in social housing. So that's priority needs. Intentional homelessness, I've already given that example at the start in terms of someone who was subject to domestic abuse, and it was the safeguarding alerts which basically formed the evidence for that kind of that argument. And then even with local connection, you're going to see it, because let's say someone flees domestic abuse from one area, goes to Council B, and Council B tries to refer them back to Council A. Council A can refuse that referral if there is any evidence of abuse or that there is evidence that there'll be continuing a risk of abuse in the area. And again, safeguarding alert often will kind of provide that level of evidence, because it's not just the safeguarding alert itself, but it's the subsequent assessment that's going to be a bit of information gathering, which can lead to a lot of useful information being held. So not only that, you've then got this idea that you can use it to push up systemic issues, because as I've said elsewhere, if all you're doing is housing the person in front of you, that's good. But if you only house the person in front of you, that means somewhere else, someone who you've never met, that probably doesn't get a service from the council, because if you don't basically increase the capacity of the council to follow the law, then that's all you're going to be doing. You're just going to be rearranging people rather than actually making sure that the system itself gets better. And back in 2015, we had a real kind of systemic issue in Bedford where every single vulnerability decision was being made was just basically rubbish. And we're having lots of cases where people were reporting to the housing officer, I am being abused by X, Y, and Z person or whatever it would be, And the council clearly in those cases were not acting on that. So again, going back to the council's safeguarding policy, anyone who first becomes aware of concerns of abuse must report those concerns as soon as possible. Well, that should have been going to the safeguarding team. So we then basically realised this was a systemic issue, made a freedom of information request, an FOI, asking the council how many adult safeguarding alerts were made by the entire housing team in the entirety of 2015. And the answer was 0. They had not made a single safeguarding referral. And simply by making that FOI request based on our knowledge of the individual cases, that then led to, I would imagine, the team getting trained and the team basically being told, you need to follow the policy, guys, because this looks terrible. And it did look terrible. We didn't even have to make the point, really. They just kind of did that without saying anything else other than that. And that in turn led to much better consideration of risk issues that kind of went forward, because if a housing officer gets told that someone's being abused, they should be referring it. That in itself is evidence that they kind of believe there is some truth in it. Even if they don't know all the details yet, that would certainly provide information that might give them reason to believe that they might be in priority need, as an example. It probably would do, but as I say, there's no hard and fast stuff for this. So certainly, as I say, it's very likely that it would do. And actually going back to this idea of pushing standards up, in the case that I mentioned at the start, where Just Us basically went back, got it challenged, Just Us then asked a question in the local housing committee basically saying, you've got these template section 184 notifications. In this case, it doesn't appear that this template letter had anything about assessing risk of abuse when it comes to intentional homelessness, which is obviously going to be relevant. And can the council basically change the template letters? And I'll put the recording from the housing committee just in a minute, just to kind of see how that worked out. But in effect, the answer was, it is in the templates, but we have noticed that the damp and mould and other issues that were raised might actually be relevant and will change the policy. Now, that response in itself says to me that maybe the housing officer just simply deleted the paragraph about abuse or something when they did the template. I don't know. But certainly the answer suggested that it was in there already, when actually there was no evidence of it in the section 184. So hopefully this is useful. The kind of main thing here is that if you are working in the sector, you need to get to know your local safeguarding policy, which might be quite a long document, but the important bits will be quite early on and you don't have to read all of it. It's just kind of the highlight bits about telling you what to do if you become aware of abuse. And you basically just need to follow it. Yes, it's annoying sometimes, but the number of times I've basically seen it make a difference in whether someone gets housed or not, it just makes it, kind of worth their weight in gold, really. And as I say, if you're going to challenge councils and say they're not doing their job right, you need to do your job right. You need to basically follow those policies to a T, even when you just think there might be no point of it or whatever. Even if you think the kind of evidence is probably not very high, that's not your job to assess. Your job is not to assess whether the section 42 criteria are met. Your job is to work out, is there some sort of reason that suggests this person is being abused? If so, I need to do something about it right now. So yeah, as always, put questions in the comments, anonymised, and I'll take it to the next live stream if you've got any questions like that. And if you haven't checked out the online training yet, please do. It's really good training. It just gives you that kind of foundation to understand how this fits together. And as I say, I'll just finish here just by inserting the recording from the recent housing committee in Bedford, just to show you how it kind of works out in practice, really. I would say if you're serious about ending homelessness and you haven't yet asked a question in your local council open meetings, public meetings or whatever, then you're missing an absolute trick. So I would say just get on it. Anything you're seeing within your casework that seems to be some kind of systemic issue, raise it as a question. There are so many different ways that can improve the way everything works. So yeah.
I had a question from a member of the public, Katie Wellborn. I was recently involved in a case where a domestic abuse survivor was mistakenly found intentionally homeless. Even though the council itself had detailed evidence on file which showed she had been a victim of domestic abuse in her previous home and therefore could not legally be found intentionally homeless from it. The template, section 184 letter that housing officers use, does touch on whether accommodation that was lost was reasonable to continue to occupy, but seems to limit this question to whether the accommodation was affordable. Will the council amend the template letter to include paragraphs that specifically explore whether the applicant had been at risk of domestic abuse in their previous settled accommodation, as well as other relevant considerations like damp and mould, disabilities, overcrowding, other abuse or harassment, cocooning, disrepair, etc., in order to support staff to make sound decisions in future?
Yep. So there is a suite of template letters that officers use, which does include specific guidance on when a property is not reasonable to continue to occupy. Staff training includes detailed learning on the reasonableness to occupy and intentionality, as well as domestic abuse. Probably worth saying that the training also covers how you use template letters. We don't actually just use a template letter. The officers are trained to make them bespoke and tailor them and identify which is the most appropriate information to include in that letter. Having checked that particular range of template letters, the guidance does cover domestic abuse along with all the other categories you've mentioned, with the exception of disrepair and damp and mould. Thank you for raising this point. We will amend the template as appropriate. I would be happy to discuss the particular case raised outside the forum as a committee. We're committed to ensuring best practice and identifying any learning from this case that we can then take.